Harish Salve. It is my pleasure to welcome you right here on ET Now, sir. Thanks very, very much for being with us. How are you reading the fact that the Supreme Court has decided to really palm it off to a larger bench today, and they do not want to, spread Aadhaar to things other than PDS and LPG?
You see, Supriya, the problem is it's not that they have done it today. The die was cast when the union government raised the ghost of the absence of a right of privacy to argue that in 2015 you can have a right to life which doesn't encompass a right to live with dignity, and you can have a right to live with dignity which does not have a right to privacy. Is taking the constitutional law back into the Stone Age. So I don't think that was the approach to be brought. Now the trouble is, under the overhang of a contention that there is no right to privacy, any constitutional court gets worried when these kind of large issues are raised. And you now have a situation where you have a group of people who are strongly saying this is going to be big brother, nobody is safe, everybody is will be under the watchful eye of the government, and on the other hand you have the government saying, hello, where is the right to privacy? So, you know, the whole thing, this application came to be decided under the overhang of a larger issue being raised by the government as to whether is there a right to privacy. So that colored obviously the manner in which the court dealt with it.
So where do things stand? Is there a right to privacy, and should that right to privacy, if at all it exists, store something like an Aadhaar which obviously has very obvious benefits?
Well, right to privacy exists. It must exist. If it doesn't exist, our constitutional right to life will be denuded of a very significant aspect. I have argued strongly in the petition filed by Mr. Ratan Tata, and the Supreme Court has heard us at length. The Otto Shankar case recognizes right to privacy. Any number of cases have recognized. One earlier bench had made certain. There was a time where the Constitution was construed literally, but those days constitutional law has evolved and come a long distance. But the Aadhaar card, in my view, the strong argument that the Aadhaar card in no way impinges on a citizen's right to privacy, that was the real point to have argued. And in fact, I argued for the state of Gujarat, saying in the state of Gujarat, please assume that privacy at its highest is available. And we will satisfy you that there is no violation of the right to privacy. And frankly, when I made this point, the presiding judge commented, well, Mr. Salve, if that is what we were hearing, then maybe things would have been different. So the trouble is, this overhang of this larger issue raised by the government as to whether there is a right to privacy is possibly what is coloring everything. I have no doubt in my mind, as a constitutional lawyer, if the matter is heard objectively, the Aadhaar card will come out with flying colors.
Mr. Salve, it's not just this time that a judge has told you if you were arguing and things would have been looked in a different perspective. I'm sure you hear that a lot more than this. But just to talk to you about the legal sanction and argument that you made by some people.
If they See, legal sanction again presupposes there is an invasion of privacy.
I get that point. But sir,
that's what I'm telling you, Supriya. If you're touching my privacy,
because this does not have the buy-in of the Parliament, this is just an executive order, and which is perhaps why the Supreme Court did not go the whole hog on Aadhaar. Do you agree with this? This needs a parliamentary sanction. It just can't be done by an executive order, and that is something that policymakers will have to look into next.
That's the whole problem. If you explain as to how the Aadhaar card is going to be run, the degree of security, is there a statute which entitles a bank to take your fingerprints? Is there a statute which entitles a commercial organization to take your fingerprints when dealing with you? If you go to a private bank, you go to a foreign bank, forget Indian banks, and they tell you we want your fingerprint, do they need a statute? So this argument is, I'm telling you, it is a specious argument, and the government is not saying that we are making, on the contrary, the government is not saying we have made a law in which every citizen has to line up and give his fingerprint. The government has made a law saying we have created a facility to identify citizens, and a facility by which citizens can prove their identity with ease. If you want the benefits of modern digital age, if you want the security of the digital checks and safeguards for distribution of resources, especially to the weaker sections, you have to find a way of doing it. Why do you need a law? The government didn't need a law to open bank accounts for all the poor people, which it has done in the Jan Dhan Yojana. I don't. So if that's the point, it begs the question to say there is no law of parliament. Does it at all impinge on your privacy rights? If it does, obviously you need parliamentary legislation.
Fair point indeed, and that's a very valid argument that you've made, sir. But very quick question, and we were speaking to a certain other people, and they said India does not have enough cyber laws to support Aadhaar being made mandatory. Which side of this debate do you throw your weight on? Do you believe that we do not have enough good cyber laws to be in place, or do you believe
Aadhaar is not being made mandatory? See, first of all, let me try and understand what do you mean by saying India does not have enough cyber laws. The database is available at the Aadhaar server at the union level. If anybody tinkers with this, it's a crime under the IT Act. What more cyber law do you need? And when a government department says, for your identity, please come, I will swipe your Aadhaar card to make sure you are who you claim to be. The only person who would authenticate that is the cyber, or the only facility there is that there is a cyber server sitting somewhere in Delhi or wherever the union government has it, which will in real time respond and say, yes, this person is so-and-so, these are his fingerprints and this is his name. Well, what cyber law are we talking about? It is not that your marital details or your medical history or your brain mapping is being put on the Aadhaar card. For God's sake, it's only your fingerprints and your biometrics for your identity. If this contained details of your marital life or details of your childhood or details of your medical treatment, I can understand all these concerns.
Fair point, sir. Before I let you go, a quick final question, because you're somebody who understands how legal things evolve from here on. By when do you expect that larger bench to take a call? And given the fact that there is an argument in favor of Aadhaar, it just cannot be restricted to PDS and LPG. It has been able to plug the leaks as the leaks are considered in the system. By when do you see a final order coming in by the larger bench itself?
No, Supriya, there's an issue now. If a larger bench is constituted, then I'm going to argue that you must put the Ratan Tata petition also before the larger bench, where we are asserting the right to privacy and all other cases where right to privacy is being asserted. What the larger bench will hear is not whether there should or should not be an Aadhaar card. They will hear a larger issue on whether India has a right to privacy, and on which some of us who are defending the Aadhaar card will be on the same side as the petitioner, saying, of course we have a right to privacy. When that larger issue gets resolved, then will come the tier 2 issue of whether the Aadhaar card should or should not be run. 9 judges are not going to waste time. 9 judges may as well say, we are not going to hear for the first time whether the Aadhaar card violates the right to privacy. So that's the big problem. I don't see this sort of playing out in the very short term in a satisfactory manner.
So then are you disappointed? My last question to you, then are you disappointed that this has not, the Supreme Court has not been able to bite the bullet on this, and something as crucial as an Aadhaar page just hangs in balance?
Well, if you're talking of biting the bullet, I think it also the government have bitten the bullet and said, sorry, we have now examined the constitution and we agree there is a right to privacy, rather than for the Supreme Court. See, Supreme Court has to decide. If the union government gets up and says we still insist that there is no right to privacy, then the court has to decide the question under the overhang of that contention.
Fair point indeed. Mr. Salve, it's always a pleasure chatting with you. Thanks very much for joining us on ET Now with your thoughts and raising the debate even further about the right to privacy and why on earth did the government not talk about it in the court. Thanks very much indeed, sir, for speaking with us.
Find us on Facebook at facebook.com/ETNow, and don't forget to click the like button. You can also follow us on Twitter at ETNowLive. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/user/ETNow.